Okay, good afternoon, everyone, and welcome to the Fight for Family Miranda, Protecting Families' Rights in Child Protective Investigations. My name is Josh Gupta-Kagan. I'm a clinical professor at Columbia Law School, where I direct our Family Defense Clinic. I'm also a steering committee member of Narrowing the Front Door. Narrowing the Front Door is a coalition of parents, youth, and family members impacted by New York City's family regulation system, working together with community activists, lawyers for parents and children, academics, philanthropists, and others. It critically examines existing approaches and works to end arbitrary, abusive, and unwarranted government disruption and destruction of families, especially by, you guessed it, narrowing the front door to the family regulation system, aka the child protective or child welfare or family policing system. I invite you all to learn more about narrowing the front door at www.narrowingthefrontdoor.org. Today, we'll be discussing one effort to limit the harms of unnecessary investigations and surveillance of families, disproportionately poor and disproportionately of color. I'll be moderating our conversation over the next 90 minutes, leaving time for some questions from the audience at the end. I encourage you to use the Q&A feature in Zoom to share your questions. But first, I have the privilege to introduce our panelists. First, we have Joyce McMillan. Joyce is a leading advocate, organizer, and thought leader, and a parent impacted by the family regulation system. She also wears many hats. She is a co-chair of Narrowing the Front Door, which organized this event. She is executive director of JMAC for Families, and she founded and helps lead PLAN, the Parent Legislative Action Network, which has made the Family Miranda bill here in New York State a priority in the legislature. Second, we have Andrew Brown, who is the Associate Vice President of Policy at the Texas Public Policy Foundation. Andrew has successfully advocated for a range of recent legislative reforms in Texas that have narrowed the scope of the family regulation system there. Most recently, and most relevant for today's webinar, he successfully advocated for the passage of Texas HB 730, which is an omnibus reform bill that includes family Miranda provisions. The Texas legislature passed that bill in May. The Texas governor signed it into law on June 9th, and it will take effect September 1st of this year. Third, and hopefully joining us momentarily, we have New York Assemblywoman Latrice Walker, who is a lead sponsor of New York Assembly Bill 1980, the New York Family Miranda Act. That bill did not get over the finish line in the legislative session, which ended recently in New York, but we know with Assemblywoman Walker's leadership, it will be back next year. For those of you who want to follow along at home or from your offices with the legislation, I encourage you to Google the following: Texas HB 730, House Bill 730, Section 3 contains the family Miranda provisions, and New York Assembly Bill 1980, or if you prefer the Senate version, which is exactly the same, Senate Bill 901, the Family Miranda Act in New York State. Let me set the context. The American family regulation system has a massive scope. Each year, child protective hotlines receive more than 2 million allegations of child neglect or abuse, mostly neglect, regarding more than 3 million children. Those allegations trigger steps by CPS agencies that can be quite scary to families: investigations, commands by CPS agencies to engage in services, threats if families don't comply. Surveillance can extend for months. For more than 200,000 each year, this process leads to the government separating families, taking children away from their parents, and opening a family court case. Those are annual numbers. The family regulation system's huge scope is even more evident when measured over the course of childhood. By the time they turn 18, more than 37% of all children will be the subject of a CPS investigation, and 53% of all Black children will be subject to a CPS investigation, again, between birth and turning 18. So this is what Family Miranda is all about. And all of those millions of investigations, what rights do parents and families have when the CPS agency investigator knocks on the door? And what should the CPS investigator be required to tell parents about their rights when they start investigating them? So Joyce, I want to start with you. What is the Family Miranda legislation in New York all about, and why is it important?
The Family Miranda Act is important because it allows families to know their rights so that they can have their constitutional rights protected, right? A lot of families don't know that the only exception that CPS has to enter someone's home here in New York, we're talking about the Administration for Children's Services, is the same authority that the police has, either with a court order or no entry. And ACS has weaponized threats against families to get in and begin these unlawful searches and seizures of information in people's homes without them knowing that they have the right to refuse entry, because the Fourth Amendment says that a government official cannot enter your home without a court order unless it is exigent circumstances. And through these threats and coercive practices, ACS entered 56,000 homes and had a court order less than 200 times, and claims that every family outside of that 200 willingly let them in and welcomed them into their home. And that's not true. And because it's not true, we're asking to pass this piece of legislation, which just reaffirms the rights that people already has, reminds ACS that families have these rights, and makes it clear as to whether or not a family invited you or did not invite you.
So what rights would the Family Miranda Bill require a CPS investigator to inform parents of?
The first right that it would require is that as a government official without a court order, we cannot come in unless you invite us in. That would be the first right. Another right they would have is to understand, if they choose to let them in and begin to cooperate without having contacted an attorney, which is also a right, that anything they say is possible to be utilized against them if the case goes to court.
Good. Andrew, the Texas legislation that passed, could you compare it to the New York bill that Joyce just described?
Yes, and I was having a little audio problems earlier. Can you hear me okay?
We can. You're a little soft though.
Okay, perfect. Okay, I'll try to speak up a little bit. Yeah, House Bill 730 in Texas is very comparable to what Joyce has described. And I think what's key about House Bill 730, and one of the aspects of this bill that helped us as we were advocating for it in Texas, is all of the rights that are listed that families must be informed of at the outset of a CPS investigation already exist, either in Texas code, in CPS policy handbook, or in the case law. And we made that clear throughout the process as we were walking folks through it. And this idea of, this is one of the most invasive things that government can do to individuals and to families. People have rights. People have well-established constitutional rights in connection with these types of interactions, and they need to know what those rights are up front. And so the rights that Joyce was just describing, very, very similar to what we put in Texas. And as you're looking at the bill, you'll see the new language is underlined. The existing code language is the language that's not underlined in the code. We already had a provision in code that provided a limited notification, or basically a written summary of the investigation process that includes some of those rights. It's, a little pamphlet handbook that a CPS investigator will give to the family. It's rarely read, as I'm sure nobody would be surprised about. And so we just kind of augmented that and said, well, yes, you're giving them this handbook. It's not as fulsome as the rights that they have. But we're also seeing that nobody's reading these handbooks that you give them. They're in a highly stressed situation. The written summary is excellent, but that should be a follow-up to, at first contact, talking the family through, hey, here's what's going on. These are the allegations against you, which is already required by federal law. And then in connection with this investigation, you have these rights. And there are ramifications to this investigation. So making sure that families are well aware, not just of the rights that they have, but also the gravity of the situation that they're going to find themselves in. Now, obviously, families are smart. They understand that this is a big deal. This is a scary process for them to be going through. But reiterating what their rights are, what their responsibilities are, as well as what some potential ramifications can be, is, I think, a very basic step that CPS should be taking in every single investigation at that first contact, just to make sure that the family truly understands what's at stake and the protections that the law provides for them in connection with that investigation.
Joyce, I want to ask you about how you and others at Plan prioritize this issue. There's no shortage of areas where I think all of us on the panel, and I know you, would like to change about the present system. But Plan selected Family Miranda as one of the top priorities for legislative action by the New York State Legislature. So why is it so important that you made it a priority? And you're muted.
It's important because when we think about narrowing the front door, we have to think about ways to accomplish that. And the best way to accomplish that is not by creating new rights, but to ensure that ACS is following rights that people already have and that it's explicitly laid out through the Constitution. As it stands now, the Constitution is literally being redlined right in front of our eyes. And for everyone who's on this call, I want to remind them that any injustice or threat of injustice to anyone is a threat of injustice to everyone. Everyone wants to celebrate Martin Luther King's Day and talk about the greatness, but they never want to be proactive in taking action towards the things that he said as a rules to live by, which support what this country is supposed to be founded on. And so that's why Miranda is so very important. And this is why it's most important that it's not about whether you believe the system should exist or any of those other things. I affirm whatever belief you have outside of the belief that the Constitution should be redlined and segregated from certain communities.
Yeah. Andrew, anything you want to add about the importance of this issue compared to all the other changes that I know you work hard on in Texas?
Yeah, to me, this issue is a threshold issue for all of those other reforms that we've been working on in Texas. We've passed some legislation in past legislative sessions, that really narrowed the definition of neglect. And when I say narrowed the definition of neglect, we didn't have a statutory definition of neglect. It was whatever the individual investigator thought neglect was. And it's where we got a lot of poverty cases being inappropriately pulled into the CPS system. And so putting that definition around what neglect is, focus those CPS investigators on the cases where they should be involved and helping them get out of cases where they really shouldn't be involved. But that's a couple steps down the road in the life of an investigation. Having this threshold requirement, again, this is first contact. This is that first time the CPS investigator knocks on the door and interacts with his family. All of this has to happen. It sets the stage for everything else that happens. And critically, the right to counsel being part of that list of rights, improves the ability of that family, to fight back. But it also keeps the agency honest and accountable, and makes sure that investigations, illegitimate investigations get done away with as quickly as possible. And even where there is some legitimacy to the investigation, that everybody's playing by the same rules of the road. And no one party has more information than the other party. And leveling that playing field, I think, will create an environment where you actually get a higher quality investigation, but you're also promoting family preservation and family strengthening, and you're not immediately just going down in a highly adversarial function, although the adversarial system is important. If we can make sure that balance of power is a little bit more even, you have much more success in terms of family preservation.
Okay. Assemblymember Walker, do we have you here? Are you able to unmute? When you are, send me a flag or unmute and we'll loop you into the conversation. So we've talked about the importance of balancing the power dynamic between the agency at the door and families, obviously in a very wide scope. There are counter arguments, right, Andrew? I want to ask you, what counter arguments did you encounter when advocating for HB 730 in Texas? And then I'll share some that I know have come up from ACS here in New York.
I mean, there's the old standby classic that we always hear is this is going to lead to more abused kids and more kids will die as a result of abuse and neglect, which I always kind of have to laugh at that because it's just become a cliche at this point. Anytime we've tried to reform the investigation process, it's the one that always gets raised. And we've been doing this long enough to where we actually have data that we can go back and look to and say, hey, we made this change. And everyone was catastrophizing and saying the sky was going to fall if you make this change to code. And the change or the increase in abuse, the increase in deaths never materialized. We saw it during COVID, especially. I think that's the really big example that we all saw. Everybody was saying, oh my gosh, there's not going to be supervision of these kids because there's not in school. We're going to have this massive spike in horrible things that are happening to kids. And then it never played out in the data. To me, that really is the biggest strength that we have, is the data and being able to push back and say, no, it doesn't play out that way. I think, again, it's a little bit of, in one way, it's an easier argument to counter because you do have that data. It is a very difficult argument in the sense of it's highly emotional. We've had multiple cases where, unfortunately, there was a recent case where a child in San Antonio was tragically killed in an abusive situation. And opponents of previous legislation that we had passed will say, well, it was because of that bill. And we were able to go back and say, no, this bill only dealt with this issue. That had nothing to do with the case that you're talking about. That issue was not present in the case that you're talking about. And so when you're pushing back, you need to, one, not be afraid to push back. The opposition is counting on, well, we don't want to feel or be perceived as insensitive to tragedies that occur. But it's important that we actually do push back and point out, no, the argument you're making is patently false on the facts. Yes, this was a tragedy, but this was a tragedy because of a failure of the investigative system, not because of the reforms that we made legislatively. So, I mean, that's one of the biggest pieces of advice that I would give for advocates is know the data. When the case is paraded out as an example of the negative implications of a reform, make sure you understand what that case is about to be able to obviously sensitively push back on the argument the advocates on the other side are trying to make. The other arguments we saw within the HB 730, we included language that is basically the fruit of the poisonous tree rule, meaning if the investigator fails to give that notification at first contact, then any evidence collected as a result of that cannot be admissible. It's a stick to make sure that the investigators are going to do their jobs. And it created a lot of debate during the process of getting House Bill 730 through. And folks, were concerned that, well, if courts can't see this evidence, then how are we going to remove a child who's in real danger if we can't use any of the evidence? And the argument, the pushback to that is we have to have some type of an enforcement mechanism. If you have a strong enforcement mechanism like this, it is much more likely that the investigators are going to comply with the law and that you'll be able to use all of that evidence, right? The attorneys for the department, the trainers, the supervisors for the department are going to make really sure that their investigators know you have to do this, otherwise it's going to compromise the quality of our investigation and we're not going to be able to use the evidence that we need. Now, that being said, if there truly are issues, there are other mechanisms in place for keeping kids safe in those instances where we do truly have an imminent danger that needs to be addressed. And so I think it's important to deal with that argument on its face, but also pull back and illustrate the entire scope of tools that are available for keeping kids safe in those imminent danger cases, the ones that I think everyone would agree that there would need to be some type of an intervention so that people don't get tunnel vision on this one very specific piece of legislation and falsely believing a narrative that says, well, if we do this, we're going to completely destroy our ability to do anything. I mean, that's a complete falsehood in my mind.
So let me ask you both to, Joyce, you want to add to that?
I just want to comment on one thing that Andrew said that I think is really important. When we're talking about child fatalities, Miranda would help narrow the scope of unnecessary investigations so that families actually who need the help become the focus, and actually, hopefully, at some point, they begin to provide the help that families need. Separation is not support. That's a misconception. And when we talk about fatalities, again, ACS entered 56,000 homes, but just recently, several children died in New York. I'm not promoting that we double the number to make it 110 or 20 or anything like that. I'm saying, let's focus on families who actually need the support and stop these home invasions that are unlawful. It's very clear that people have a concept that Miranda is an approach, right? Or that Miranda is something that needs to be figured out. The language needs to be figured out. It's not an approach. It's a right. We're just trying to ensure that everyone who is protected under the Constitution is allowed to exercise their right under the Constitution. In these red line communities, when a person says you cannot enter my home, they weaponize the armed police against them. That is not giving someone the ability to exercise their constitutional rights and to live and feel safe in their own home. That is doing the exact opposite. It is saying you don't have the right to deny us the ability to traumatize your family, search your premises, not advise you of what it is we're doing here, why, how we got here, or any of those things. Just come in and bulldoze you in your own home. It's inappropriate. It's not a theory. It's not any of that stuff. It's something that we are all entitled to living here in America. And I think Ms. Walker has her hand up.
Thank you so much. You know, Joyce, your energy is just so infectious. And I always remember the day that we've had an opportunity to speak about your story and got to trade stories about things that, you know, I was going through, people in the community were going through. And so I am grateful and thankful to all the folk who put this amazing forum together and for allowing my participation in it to be a sounding board for amazing advocates like Joyce and many others to really be able to understand that we need to protect our children, but protecting our children requires us to have a holistic approach. And the quasi-criminal nature of protection, or the perception of protections of Black and Brown children, has not worked. And the same levels of constitutional safeguards to ensure that our babies aren't just removed from our communities in the same way they remove our men and women unjustly and unfairly, that these same constitutional safeguards needs to be presented here at the same time. We know that when a child is removed, it's generational trauma. We were going through a set of circumstances in our country where everyone was saying, keep our families together, but yet and still agencies such as ACS have been ripping our families apart. Now, mind you, we see the egregious nature of so many stories about young people who are in harm's way each and every day. And we want to do everything in our power to protect the most vulnerable babies in our communities. But we also note that the numbers don't lie, that most of the people who are brought up on these sort of family-based charges are unfounded. But the ramifications on both the parents and the child are long-standing. And so we understand how important it is for a family, for a mother, for a father, to know their rights with respect to the over 50,000 warrantless searches of homes that happen within our community today, disproportionately those being of Black and Brown families. Without a court order, we know that it violates the Fourth Amendment, which protects us from illegal search and seizures. And so the bill, the Family Miranda Act, which was introduced, would protect our families for those types of service workers who wants to utilize ACS as, a police, criminal agency, as opposed to the type of agencies that should be there to support parents and caretakers, whether or not they're in trivial times or not, as opposed to being sort of like a gotcha. And so workers would have to inform parents that they have a right to an attorney. They have a right to have an attorney present with them if they have to undergo any questions, and that they also have to understand that they don't have to allow Child Protective Service agents to examine or interview them or their child or their homes. Similarly, they don't have to agree to drug or alcohol tests or submit to mental health violations, because we know that all of these things will be utilized in order to remove a child from the home. Now, mind you, if there are exigent circumstances or if there's some imminent danger, we want that child to be removed immediately. However, there still needs to be a process and procedures that are in place to ensure that young people are not unnecessarily removed from their homes and our communities be exploited and targeted by Child Protective Services at high rates. And so these are some of the things that we have been talking about with the Family Miranda Bill. It has gained a lot of traction in this recent legislative session, though we didn't get where we wanted to go. There is still a lot more work to be done. And I see that there are over 200 people on this call. And so I appreciate, the enthusiasm. Again, as I mentioned about Joyce, it's inspiring. But one of the things that I would love it if we could do is to, get on our emails or our phones and call my colleagues in the assembly and let them know that if we go back to session, that we need to bring this bill to the floor and let's take a positive vote on this bill immediately, because our families depend on it. So thank you so much for allowing me to sort of have my 2 cents. And it's always, an honor to follow you, Joyce.
Thank you for being a champion, Assemblywoman Walker. We could not have gotten as far as we did without your help, your assistance, your guidance, and your leadership. So thank you.
So I want to follow up on one theme that's come out in all of your comments, which is what happens if, so Family Miranda is the law, ACS or any CPS agency knocks at a parent's door, reads them their rights, and what if the parent says, no, you can't come in, I'm going to assert my rights. What happens next?
You go to court and get a court order, which is what they should be doing initially anyway. And I want to make this clear because I'm sure a lot of people on this call work within the service industry or within the world of child welfare. And so everyone should reasonably understand two things: that there's over-reporting because mandated reporters are confused about what it is they're supposed to report about. And they have a model that they are now just talking about changing that utilizes language I created, mandated supporting. That's a whole nother story.
Mhm.
But I mean, it's flattering, right? But I don't want you to just utilize the language. I want you to actually conceptualize what that means and put it into practice. That is different than changing the face of what it is they're doing while continuing to do the same harmful things. When someone calls the state central registry, a recording comes on that says, if this is an emergency, please hang up and dial 911. That person we are trusting to be able to report a concern about a family stays on the line. Now we trust this person. They then speak to an operator at OCFS, the Office of Children and Family Services, who we also trust, right? They take the complaint, they ask all of the relevant questions that they need to be asking, and they find out this kid came to school with dirty clothes. ACS will say we have to investigate all cases. I'm not concerning myself with that. But the important part of the family saying no at that point and them going to court is because it gives a judge the ability to say that this is not probable cause, and we're not going to give you an entrance order into this family's house because a child had dirty clothes on today. Give me something more tangible that says this child is at immediate risk of harm, or something closely related to that. And so ACS will say if the family denies us entry into the home, they're using the same song they sang during COVID, which wasn't true then, and it ain't true now. If we don't let you in our home, our children are actually safer. The data from COVID shows that families were safer together. They thrived with a little cash infusion and other assistance that was given to families that often lack some of the necessities the family should have in a home. And instead of this being a practice of CPS across the United States, not just in New York City, we take children out of the home and begin paying people trauma therapy for the trauma we're causing them. We begin drug testing the parents, even though it wasn't a drug-related case, just to make sure it's safe for the kid to come back in the home. We begin doing all of these things, including paying a foster agent that they call a foster parent, who's contracted by the government, who violated their Fourth Amendment rights from the beginning. It's insanity. It's insanity. And anyone who tells me that they're partaking in this because they care about children is either stupid as a brick on the side of the road or just really don't give a shit about families. There is no in between on that. The message is clear. We all understand what it is. And either you are doing this purposely because you think without doing it, you're not going to have a job, or you just really, truly lack understanding and should actually be in therapy yourself.
I'm going to play the role as both moderator and my day job as a law professor, just had my introduction. So I'll note a couple boring points just to underscore things that both Joyce and Assemblymember Walker and Andrew all alluded to. So one is, if a parent says no, there's a procedure for a CPS agency to go to court. In New York State, for New Yorkers on the call, it's the Family Court Act, Section 1034. ACS or upstate or Long Island County can go to the family court, petition the court, show probable cause that there's neglect or abuse going on. And if the judge agrees that the evidence supports it, the judge will issue the equivalent of a warrant to enter the home. Assemblymember Walker also used the phrase exigent circumstances. If there's an if the evidence shows that there is an immediate immediate risk of harm to the child, that can authorize the authorities to enter the home and do what they need to do to protect the child. And both of those legal points are part of the response to this. Oh, but children are going to be left in danger if parents start asserting their rights. I'll also note that under the New York State Family Court Act, family court judges are supposed to be available pretty much at all hours for to issue a warrant if needed. I'm going to pause and tell you a little bit more about ACS's perspective. Narrowing the Front Door invited Jess Danhauser, the commissioner of the New York City Administration for Children's Services, to join this webinar. Commissioner Danhauser declined, citing some scheduling conflicts, but he did offer to talk with us about ACS's position so that could be shared in this webinar. And I was able to talk with him and an ACS attorney about that earlier this week. So I want to relay some of what he shared and then invite feedback from all three of our panelists. So first, Commissioner Danhauser acknowledged that parents have the right to not let ACS into their homes at that knock on the door, and he said parents should be informed of that right. But he was less supportive of the other rights that they would be informed of under the Family Miranda bill. And he listed three specific objections, and I want to summarize them in the order he raised them, and then I'll invite feedback from any panelists who want to weigh in. First, ACS said they're concerned about Family Miranda's impact on the family courts. I think the logic goes like this. If more parents are informed of their rights, more parents will assert their rights. And then ACS will have to go to family court more to seek those court orders, the equivalent of warrants, to enter homes. Again, only when ACS has sufficient evidence to convince a judge. And ACS says they're concerned that this could overwhelm family courts and further exacerbate long delays that already plague family courts. Any responses from any panelist who wants to weigh in?
Yeah, this is one we get a lot, of the concern about overburdening the court system. And my blunt response, and I would be much more tactful if I were speaking to a judge because I'm an attorney and we have to be nice to the judges, would be, so you don't want to do your job. You are in this position of public trust, and in Texas, we elect our district court judges who have these, who have responsibility over these cases. The people of Texas have placed you in this position of authority, and we expect you to be a judge, to take on these difficult cases, to make these decisions. And yeah, you're going to have a busy docket sometimes, and that's part of the job. The constitutional rights of families trump your busyness. Full stop. The constitutional rights of families are the preeminent consideration, and you are placed in a position of authority to safeguard those rights. And yes, sometimes that means you're going to have a busy day at the office. Sometimes you'll, have to do odd hours in responding to some of these requests. Another thing to think about with process and how this actually plays out. Now, I'm not exactly sure if it's the same way in New York, but a lot of times these orders will get issued over email. An investigator will email a judge and just say, hey, here's what we've got. I need to get an order. We call them an order in aid of investigation. Here's my evidence. And they'll correspond over email and the judge will issue it that way. So there's not necessarily you actually physically have to get in front of the judge requirement for many of these types of orders. Now, with Zoom hearings as well, it's much easier to physically or virtually be in front of a judge if you really do need to act quickly to get an order in aid. That brings me back to a point that Joyce made about going to get the court orders. For advocates who are pushing for Family Miranda, be aware of how that process works of getting that warrant or that order in aid of investigation. We had to tackle that issue as well in Texas because we didn't have a probable cause standard in our statute that dealt with orders in aid of investigations. The other question you need to ask yourself is, okay, how is the agency going to try to get around this? And we've seen in Texas, even before Family Miranda was passed, the orders in aid of investigation essentially being abused to where if a family exercises a constitutional right, one real world example was a family said, we want to consult with our attorney before we let you in, and had the attorney on the phone while the investigator was standing there. That investigator went to court and used the fact that they exercised that right as evidence to support getting the order in aid. So they're actually using the fact of exercising a constitutional right as a negative against that family in order to gain entry to the home. And so as you're looking at Family Miranda, also look at what are those standards for getting that warrant or that order in an investigation, to make sure that there's not a loophole that could potentially undermine the strength of the Family Miranda, or there's not a practice where exercising the rights, it could be then used as evidence to gain entry into the home.
Excellent warning. Joyce or Assemblymember Walker, anything you want to add on that concern raised by ACS?
Some things I don't even like to address with ACS because it's just so ridiculous. It's really just a distraction. Your concern is not to worry about courts being overburdened. Your concern is about trampling on the rights of people. And that should be your concern. Your concern should be traumatizing children unnecessarily, children that you claim to protect with the outcomes that you have. Focus on that. Mind your business. Stay in your lane. Be respectful in your lane. Be responsible in your lane. And don't tell me about the courts. And don't tell me that families are going to be confused by utilizing the word Miranda because it's going to scare them more. You've been terrorizing them for years. You've never been concerned about families being afraid of your terror attacks upon them. And now suddenly you're concerned while you continue the same practices and fight against Miranda without clearly saying that you don't want Miranda. You're watering down the language. You're taking out the word rights. You're doing all of this stuff that's nonsense because the Fourth Amendment says that we have the right to refuse entry to a government official without a court order. And when you took that call at OCFS and you screamed it, you knew there was no emergency. You had more than enough time to go to court, follow the protocol, follow the law, set an example, and stop terrorizing Black communities and stop encouraging lawmakers to assist you under the guise of protecting children to redline our communities and prevent us from exercising the same rights that everyone else has to them and feeling safe in our homes. We're not safe on the streets. We're not safe in the supermarket. We can't bird watch. There's nothing we can do. And now you're trying to tell us that we won't be safe in our homes either. This has to stop. Where do we draw the line? I need lawmakers who came to Harlem the day that the first children from the border arrived to be placed into the foster system. And they were all outraged. And they was holding up signs saying families belong together. And many of these lawmakers look like me, but I haven't heard one of them speak about the children that are removed at the border of Harlem, the border of Brooklyn, the border of Queens, the border of Staten Island. I need you to step up and be consistent across the line. If families matter, then damn it, I want all families to matter.
Hard to follow, Joyce. Joyce anticipated the next question I was going to ask, and I want to ask it again. The second concern that Commissioner Danhauser raised. He said that ACS is concerned that reading all of the rights, not just you have the right to not let us in your home right now, but that anything that you say to us can be used against you if we go to court. Right? ACS is concerned that reading all of those rights to parents will make parents scared. And in particular, will make them scared that they're about to be arrested. And they continue, not only is ACS not arresting parents, but in the vast majority of investigations, they're not substantiating allegations and they're not removing children or filing family court actions. So don't scare parents, ACS argues, by reading them all of the rights included in the Family Miranda legislation. I think we heard at least part of Joyce's response to that. So Andrew, I'll turn to you to see if you have thoughts on that objection.
Yeah, Aaliyah in the chat just jumped to the answer. We are already scared. Yeah, They're already scared. CPS is at the door. Families are smart. They know what this means. You're not going to scare them any more than they already are by saying, here's the rights that you have. In fact, if you're telling them that they have rights, you should be reducing that fear factor because at least you're communicating, yes, this is serious. Yes, this is scary. However, the Constitution of the United States, the laws of this state, provide you with protection. And we want you to know about the protections that you have in connection with this very serious, very scary process you're about to go through. The fear question, we're going to scare parents, never really, to me, rose to the level of being a serious concern, because it's completely disconnected from the reality of what families are experiencing. And I think it's patronizing as well, because it fails to acknowledge the intelligence and the agency that these families have. They don't know what's going on. Absolutely, they know what's going on. Give them more information about what's going on. You know, anytime you're in an uncertain situation, where does that fear come from? The fear comes from the fact of, I'm not sure what's happening right now. The more information you get about what's happening, the lower your blood pressure gets, because now you've got information that can help you navigate what's previously seemed like an overwhelming situation.
And I'll add, one of the things that's interesting about this argument, to me at least from ACS, is they're not challenging the accuracy. They're not saying it's wrong. We won't use what you tell us against you in court. We want to talk to you first before we fully provide that warning to you, right? Which I think everything you said, Andrew, and everything you said, Joyce, is on point.
I think the more honest response is, we want them to be afraid, because if they're afraid, they're going to talk more, because you're going to try to talk your way out, and we'll get more information we can use against them. The fear actually helps me as an investigator to get more information that I can then use to remove this child.
Yeah.
Say it louder, Andrew, for the people in the back, please.
And on that moment of alignment, this is a bit of a station break, but I just want to acknowledge what is probably obvious to most of you watching. We've got Texas and three New Yorkers on this panel. Politically different states most of the time. The Texas Public Policy Foundation is a conservative-leaning organization, I think Andrew is fair to say. Most of the New Yorkers on this call, I suspect, are not. And yet we're aligned, and to our New York friends, Texas has out-progressived us with its enactment of Family Miranda. And one of the fun things is crossing over those otherwise divergent ideological lines. The final objection that ACS raised, I think we've talked about this, so I want to say it out loud. ACS expressed concern that Family Miranda would lead to ACS learning less information about a family, and thus be less able to make fully informed decisions about children's safety. This is how they expressed it. And ACS expressed a concern that in some cases, that there were some cases, a minority, they made clear, but still some cases, that lack of information to ACS could leave a child in an unsafe situation. I know we've already addressed the safety concern. Is there anything else either of you would like to say? I also add, Assemblymember Walker is still on. Hi, Assemblymember Walker, but is having tech issues, and so isn't able to respond, but I know she's online, and if that changes, I'm sure she'll let us know. Joyce or Andrew, anything else you want to say on that objection?
I want to simply say, again, addressing the things that ACS mentioned are just ways to distract from what the real facts are. I'm not going to be distracted by them. They're dishonest, to say the least, right? They're dishonest across the board in every shape, form, and fashion. First of all, they told you that they were there to protect children. Have you looked at the outcomes lately? Can you tell me anything they have protected a child from other than success? They parade around 6 kids that luckily, by bare chance and I don't know what, made it to college. And then they ask for millions of dollars for fair futures, but there's only 6 kids going to college. The rest of your kids are incarcerated, homeless, in mental institutions, living on the street. What are you talking about? Stop lying already. Say what you're really here to do, or do what's right. Like no one's fooled by you anymore. The secret's out. You're not helping. I've never seen a person run from an ambulance. I've never seen them be afraid that the stretcher was coming to pick them up. I've never seen a person in a burning building be afraid that the fire department is entering. But somehow you claim to help and everyone's fucking terrified.
So I want to raise a question from the other end of the spectrum. And it starts with this point. We know from where the Miranda rights, the right to remain silent, et cetera, applies in law enforcement investigations. We know that a strong majority of people who are suspected of committing a crime, who are read their rights by the police, still end up talking to the police, right? They don't say no, right? And anyone who has done criminal, I'm speaking as a lawyer, law professor, folks who have done criminal defense work or juvenile defense work, who have advised clients, don't talk to the police, they can pretty much all tell you stories of clients who disregarded that advice, usually to their detriment, right? So do you expect the same thing to happen if CPS agencies have to read people their rights? And if so, if most people are going to talk to ACS anyway, why is this so important?
Yeah, I would suspect that we see similar patterns with family Miranda that we see in traditional criminal Miranda, primarily because of, again, that fear factor of, well, if I cooperate, it'll go easier on me. That's where the education piece is so important. And for the attorneys that are on this call, making sure that you're doing everything you can to get your clients to understand what's going on. Now, you have a risk factor here because this has to be delivered at first contact, right? And so more often than not, that first contact communication will be prior to the opportunity to consult with counsel. And I think that's a barrier that we have to figure out. How do we deal with that? Just reality. That's going to make it more likely that people would waive these rights. For the community organizations that are working in communities that are disproportionately impacted by child protective services, let them know, get this information out there, right? You can kind of create a community Miranda without the permission of the legislature while you're still fighting to get the legislature to force CPS to do this. Educate your communities and educate your neighborhoods, because like Joyce said, these rights already exist. We're not creating rights. So you can exercise these rights regardless of whether somebody told you you have them or not, as long as you know you've got them. And so I think that's one way we can get out in front of this, especially while y'all in New York are still working to get the bill passed. Get into those communities if you haven't already. I'm sure y'all have. But make sure that information is getting out there to families preemptively as you're working the legislative process.
So I want to ask you both, what's next in your respective states? So Andrew, I'll start with you, since you're starting to talk about this. You're about to be implementing, Texas is about to be implementing Family Miranda starting September 1st of this year. What are the keys to implementing it effectively? What are you worried about in implementation? What do folks need to do to make sure it's implemented the way it's intended?
The first key to implementation for me is the data. I want to see that it's being done. The rulemaking process will be ongoing, so I'll be watching what our Department of Family and Protective Services publishes in their policy handbook. And to their credit, they put a lot of stuff online. They've got a great interactive data book. They put their policy handbooks on the computer. I'm signed up to a listserv where they will actually email every single time they make a change to policy. And you can look at what that change to policy is. So that's the first thing I'm going to be looking at. And because of relationships that I have being a policy advocate, I'll be having conversations with the authors of the bill who are following up on the implementation, as well as contacts that I have within the department who will be responsible for implementing it, to hopefully provide insight and feedback on, this is the intent of how you implement this, right? I tend to, as much as we beat up on the department here and as much as we point out what they're doing wrong, I also want to have a positive working relationship with them and be helpful, especially with reforms like this, and say, this is how you implement it. Let us help you implement this. And we've been seeing some progress there. We have a new commissioner that was recently appointed, and I made a comment to a colleague the other day that this was the easiest they've been to work with in my entire career, actually giving positive feedback on reform that we're working on and saying, here's how our process works, and working with us with the language to make it easy for them to actually implement in terms of their existing processes. So there was a much more cooperative spirit that we saw this legislative session that we hadn't seen in the previous sessions, which I think comes down to leadership. But really taking advantage of that brief, sweet window of time that we have right now of cooperation to make sure that things are executed well. The other piece with implementation, again, I'm going to talk to the attorneys in the room. I rely so much on our family defenders who are out there, who are seeing these cases in real time, to call me and to say, hey, I'm working on this case right now, and this is a problem that I've noticed with the way this is being implemented, or there might be a loophole in the legislation that we didn't see when we were working through the process that we want to go back and fix later on. That intel that's coming from the field as the new processes are being implemented is critically important to make sure that, one, things are being done the way they're supposed to be done, and two, help us identify other problems that we can come back and fix in the next legislative session. There's always oversight. No piece of reform is ever going to be perfect. The law is a complex thing. So that open communication with practitioners and folks in the field is critically important for my job.
And to underscore that point and what you were saying earlier, the role of counsel for parents before a petition is filed, pre-petition advocacy, early defense, as it's known in New York City, is so important. Access to such counsel varies a lot depending on where you are. If you're in New York City, you can call one of the institutional providers, get early defense. A number of other places around the country have it, but not everywhere. So if you're from somewhere that doesn't have it, work with your local legal services offices to try to figure out how that can be provided. Joyce, I realize I didn't give you an opportunity to respond to the prior question. Wasn't sure if you wanted to add anything or go into what's next in New York.
What's next is to continue to circumvent their circumventing of people knowing their rights by continuing to put up bus ads, subway ads, marketing ourselves however we can to get the message out, going into schools, going into hospitals, going into the community, going into housing projects, going into the neighborhoods that are most highly impacted, those red line communities, giving out flyers, having conversations, and just educating the people and letting them know what their rights are. And hopefully there can not just be lawsuits against ACS for violating Fourth Amendment, but for the police who assist them in violating, knowing that there's not exigent circumstances when they arrive. And so that's my work. And if anyone really believes in the work that we're doing here at Narrowing the Front Door and JMAC for Families, you can always donate through the narrowingthefrontdoor.org website to help us to promote and help to keep families safely together. Or you can go to the JMACforfamilies.org website and donate directly to JMAC. Whatever you prefer, the work is being done in coalition, and we will utilize this money together in coalition to educate communities and try to help keep them safe from the grips of ACS and their volatile approaches to families.
And I'll just add as a tangent and echoing something Joyce said earlier, if you or anyone you work for has used the phrase mandatory supporter without citing Joyce, you should think of such a donation as a royalty for the the uncited appropriation of the phrase she coined. We have at least 8 questions in the Q&A, so I want to start making sure we get through those. And I'll invite folks who are listening to add more questions to the Q&A if you have them. So the first, which was an anonymous question, asks wondering if there are counties currently implementing or piloting this approach. So are there places, obviously Texas will start September 1, but are there places today that are following Family Miranda?
Well, ACS did something that they called implementing, closely associated with, where they were piloting, advising people of what they think families should know, not actually their rights. So it was things like, if you let us in and see the kids and ensure their safety, we'll tell you that there was a neglect case. Like it was just such foolishness. I can't even really remember. It was bananas. It had nothing to do with what people's rights were. And they were calling it a palm card, I believe. And they tested it out maybe about a year ago. Maybe someone in the chat from ACS could speak more to that. I mean, one of the participants that's from ACS, maybe they can jump in the chat and tell us exactly what that was. But whatever it is they're calling it, it was not efficient or effective. And so we're just trying to get to a place where things are efficient, effective, and respectful to our constitutional rights. That's all we want.
I will note that I believe the state of Connecticut has had family Miranda in their statutes for a couple of years. I don't have when their enactment date on the tip of my tongue, but they have had and have been implementing it. I don't know if there's anyone here from the state of Connecticut. Anywhere else that you know of, Andrew?
Not off the top of my head, no.
Okay, next question in the Q&A, and this is from John Kelly. So I'm guessing John Kelly, the journalist at the Imprint, although John Kelly is a common enough name. He asks, Andrew, who or what entity will be responsible for creating the actual phrasing of the verbal notice that parents will hear, or has that work already been done?
So the actual phrasing of the verbal notice will be created by the department through the rulemaking and policymaking process that I was referring to earlier, which is one reason why I'm watching that so closely, to make sure that what they put into place is faithful to what is in the legislation itself. And we were very detailed in the legislation of saying, these are the very specific things you have to inform families of. So the hope is you don't give them a ton of wiggle room in the way that they're drafting these advisories. But again, that does happen through the rulemaking process. So the department itself will be putting that together and training their people on it. So that's why we watch the rulemaking process very, very closely. And that's something, for other advocates to keep in mind. Your job isn't done once the bill's passed and signed by the governor. You need to be involved with the rulemaking process, because most reforms do allow the agencies to determine how they're going to implement.
In terms of implementation, John added in a chat, I think just to the hosts and panelists, that he believes that Connecticut provides these rights in writing as well. That's how they've implemented it. Sounds like Texas had done that prior to the most recent legislation. Next question. Did the fruit of the poisonous tree provisions, the provision that say if the CPS agency does not provide these Miranda warnings, any evidence that results from that should be suppressed, not admitted in court, did that provision survive in the Texas legislature? Does the legislation as passed provide that all evidence obtained following the failure to provide notice of rights can be thrown out?
Yes, it did. And if you have that, I'll drop the PDF again of the bill into the chat. I dropped it at the very beginning. If you go to page 7 of the bill, it's 261-307 subsection E. If the person who is the subject of the investigation does not receive the verbal notification and written summary required, any information obtained from the person and any other information that would not have been discovered without that information is not admissible for use against the person in any civil proceeding. So there is a little bit of a wiggle room there and some flexibility around criminal proceedings, but that's the scope of the fruit of the poisonous tree provision that we were able to keep in the Texas law.
Okay. Here is a question from Richard Wexler. Andrew raises an important point about agencies actually using a family's assertion of their rights as grounds to violate those rights. If it's not in there yet, could the family Miranda bill, and I'm guessing he means the New York one or the one in Texas or any other state that writes one in the future, could the family Miranda bill be amended to include a clause specifying that agencies and family courts may not use the fact that a family asserts its rights as grounds to seek a court order, and judges may not take that into consideration, as in the authorities can't use one's assertion of one's own constitutional rights against you? Thoughts from
Yeah, that's a great suggestion, Richard. I'm scrolling through and I don't believe we have language in there that is directly on point with that suggestion. I think that would be helpful. You know, we have some case law in Texas that's friendly to that point. So for the attorneys, they have case law that they can cite that says the family's exercise of a right does not create the ability for CPS to get that order of native investigation. There was another section of that bill, and Joyce, if you want to go ahead and start talking, I'm going to do a quick search to see if we maybe added it. It's been a long session, so
I just find it really interesting that I do know that judges not only hold against families asserting their rights not to let ACS into the home, but they also hold against families when they refuse to go to these child safety conferences and family team conferences that ACS is only utilizing to section off the parent from their legal team so that they can gain more information and more insight, agitating them. I've been to these conferences numerous times. They're information gathering sessions. But when families say, I don't want to go without my attorney, the attorneys are not invited there, somehow or another is held against them. So judges also have a lot to learn. And I see that we have some people on from the New York City courts. And I hope that they can be of assistance in ensuring that judges do their job to help keep ACS in line and to help families feel more safe in protecting themselves and exercising rights that they have. But before you go back to the questions, Josh, I just want to add one more thing. The bigger picture of danger when ACS enters a home without a court order and they coerce families, which they say they don't, but I have a family I'm working with right now who's been in their preventive services or cares, whatever it is, I get them confused. Whatever they was forced into, they've been there for 3 damn years, and the family is saying, we don't want no more of this, we want to come out, and they're right back at square one, where ACS is telling them, if they stop at this point, they're going to take them to court, which was the same threat that got them to sign up for these services anyway. So it's like creating a shadow foster care system in a way, where people don't really know how many families are under the surveillance of ACS, because you can't trust them. You can't trust their data. There's nothing about them you can trust. Be clear, be honest, actually do what you say you're doing. Stop pretending to do it. And let's support families and communities. Stop wasting your $3.5 billion budget to investigate and terrorize communities. Stop with your racist tactics and begin to support communities so that everyone has an opportunity to thrive.
Excellent. This conversation leads to a question that Nikki DeSalvo from a survivor-led movement posted in the Q&A. Are there concerns about Texas and New York City family court judges responding to CPS agency requests for court orders? In my experience with survivors of intimate partner violence, family court judge accountability is a joke. That's the question. You've raised, Joyce, concerns about what happens in the courts. In the abstract, we want them to apply 1034 meaningfully and not issue a warrant unless there's adequate evidence to support it. Are either of you concerned that family court judges will honor that in the breach?
No, I think that oftentimes judges throw the law aside and implement a ruling based on their implicit biases. I mean, think about the process of court, of family court. How we get to talk about all of this stuff that they say matter, that doesn't matter. And if it does matter, we should be at a trial talking about it, right? They get to just say it in the court while the family, the parent has to be quiet while everyone stares at them to see their body language. And we're drawing conclusions off of this body language. If they respond, they're upset, they're out of control. They got a mental illness. If they don't say anything, they don't feel anything, and they don't care about their kids. There's no win in what you can or cannot do. And we need people to stop judging us for how we respond, how we look, how we dress, the amount of money we have, and start applying the law, holding these agencies accountable that's there to help, and tell them help isn't help if it doesn't help. And I can assure you, if every parent on this call right now dropped in the chat, I'm a parent and they didn't help me, you can begin to get an understanding this service does not help. It's not a service, it's a threat. And it's just a horrific circumstance to be caught up in. I was caught up in it. I know what it feels like. And I hope today that I'm your worst nightmare, because you should have never did what you did.
I'm going to shift gears for a moment. A question from Mega Sardana. What can New York learn from Texas, a politically conservative state and one that perhaps we wouldn't think of as progressive in terms of family rights, in getting this legislation across the finish line?
Yeah, thank you very much for that question. And I had to laugh the other day when y'all let me know that people in New York were saying Texas is more progressive than New York, just being a conservative, because
on this issue, Andrew,
I don't view this issue as a progressive or a conservative issue. I view this as a simple issue of basic constitutional rights, which I think is something that defies party labels. And that's really how we were successful in Texas. I always say that the life cycle of a major reform like this is generally 2 to 3 sessions. If you're not going to get it done the first time, more often than not, because it's a new idea. And the legislators, at least in Texas, they're here for 140 days every 2 years. We have a very part-time legislature, and they're dealing with a whole host of issues at any given time. And so it takes time for legislators to understand issues, to hear from constituents, and that socialization process happens both during session and outside of session with, research papers, op-eds, news hits, keeping that flow of information going to raise the profile of an issue like Family Miranda to the point where when the legislators come into session and you start talking about it, they remember, oh yeah, I heard a story about that, or there was this court case about that. I know what you're talking about. So that education process is incredibly key to being able to get the bill across the finish line. The first year we proposed this legislation, we actually had a Democrat lead author on it. And we made some pretty good progress with it. This session, we have the chair of the House committee that oversees our CPS agency actually as the lead author. And prior to this session, as we were working on our slate of bills for child welfare reform, he specifically came to us and said, I want Family Miranda as part of a broader CPS reform package. We got to make sure it gets done this session. I tell that story to say having leadership on board is key. And so doing that groundwork to educate key members, to finding the members who want to make this arena an area that they specialize in, that's really, really hard, because this is a complicated area and you get more bad news than you get good news in the media. If it bleeds, it leads. Old cliche with the media. They want to cover the horror stories. And so that's what you're having to deal with. And as a legislator, that's a hard place to enter and to say, this is what I'm going to specialize in. This is what I'm going to stake my reputation on. So finding those people and cultivating them, building a bench of legislators who are interested and passionate in making change in this area is critically, critically important. Now, we were very, very fortunate in Texas that we do have a chair of the House Human Services Committee who has been involved in this space, for his entire life. He's an adoptive parent, he's fostered. And having that perspective has actually made him an advocate for increasing the rights of families and seeing how difficult this, not how difficult, just all of the corruption and all of the violation of rights that occur within this system. I think we've found a little bit of a diamond in the rough in several members of the legislature who actually get it and who want to solve the problems. And so when you find those folks, make sure you're doing everything that you can to give them what they need to be successful, and that you're promoting and praising them and holding them up as the leaders that they are on these issues.
Joyce, anything you want to add on what can Blue State New York learn from Texas?
You're not as progressive as you claim to be. Everything with New York and is under the guise of, right? Pretend, fakeness. It's not real. If you really want to be progressive, start by being truthful. If you really want to be progressive, start by ensuring that everyone is treated equally, that there's equity for families of color and equity in all communities. Stop talking about it and start being about it. Talking about it means nothing to me. I want to see the impact of the changes in my community. I want to hear a family call me up and say, Joyce, I was actually helped by ACS in their intervention. Not that they separated my family because I didn't have the medical coverage that would allow my child to have that operation. And the only way that child could receive those services was to be in your custody. Like, that's just sick. I don't even know why you would even create something that's designed that way. And I don't know how we're upholding this in good consciousness. This is a moral issue as well as an issue on many other levels, but it's morally unacceptable in 2023, half the year gone, to still be acting like we're in the 1930s, where Black people don't have the same rights. It's ridiculous. We are far behind even where the civil rights era was with this. This is not a debate. The fact that we're having this debate and that we have to explain to all of these intellectual people who are on here with all sorts of degrees what the Fourth Amendment means, it's not that you don't understand, it's that you don't care. So be honest and say you don't give a shit. Don't gaslight me and tell me that you care, but you're concerned about the safety of the children when you take them out of a safe home and a home that could be even more solid and safer by supporting it, to put them in a system and set them up for complete failure. I got a judge right now who would not send a woman, and this is a case, of course, here in New York, the judge would not send the woman's child to live with family outside of New York, but is now sending the child overseas on vacation with the foster family. The reason they couldn't send the child out of state because the interstate compact takes so long, and because they can't monitor the child outside of the state. Well, how the hell are you going to monitor the child on a 14-day cruise to another country? Tell me that. You're telling me that, oh, it's going to be a wonderful experience for the child. If it's going to be so wonderful, give the money to the mother and let her take them. Let them enjoy that experience together. Get out of here with your nonsense. It makes no sense, and I'm really tired of it. And I have no etiquette in how I speak to you guys, because you guys show no etiquette when you're interacting and speaking with families, and I'm going to give you back what less empowered people feel like they can give to you.
I want to highlight two comments in the chat about this issue of politics that I know I've raised. One rightly notes that in Texas, the law passed unanimously or nearly unanimously. It was not a partisan issue when it came down to the votes cast. The other comment I want to note, someone said, the success in Texas gives me hope that this can pass here in Tennessee. And I know we've got folks from states all over. Texas and New York are not actually the centers of the universe. We've got folks from all over the country. And to state explicitly what I'm sure is implicit, for those of you interested in this topic, there's no reason you have to wait for Texas or Texas has acted or for New York to act. You can introduce your own family Miranda bills, talk to elected officials, form your own advocacy organizations if you'd like in your own states. We have time for hopefully one or two more questions. Here's one from Mining for Gold, I think is Corey Bess. It's directed to you, Andrew. How much influence did impacted families have on this passage? And if so, how will they influence or support accountability implementation as intended?
Impacted families were key to not just this passage, but for broader passage of multiple reforms that we've had over the last several years. I always say I get paid to be in the Capitol visiting with offices. I have good relationships there, but eventually they get tired of hearing from me because they hear from me all the time. And the best thing that we can do to get reform accomplished is show how it's actually impacting the people in our legislators' districts, how this will change their lives for the better. During our planning process, believe it or not, we've already started with our legislative session wrapping up. We're now thinking 2 years ahead. One of the key questions that we always ask when we're setting our agenda is, will individual Texas families see a change? Will they feel an impact if this bill becomes law? And that's the framework that we view any reform through. And so having those families actually showing up, and for the last several years, we've had multiple families showing up, telling their stories in various contexts. And the more that happens, and even if you don't have a specific family matched up with a specific issue, we weren't able to get families on every single reform that we were able to pass, but we had a steady drumbeat of families that were all telling very similar stories of how their rights had been violated, of how their families had been wrongfully separated, of how their families had been traumatized, and the long-term negative impacts of their involvement with the CPS system. That creates a narrative, and you eventually get to a point where the more of those stories that an individual legislator has heard, the more open they are to reform ideas. Now, we're getting into a point where we've had so much success in Texas over the last several years on the family rights and the parental rights front that we're now talking about how do we need to pivot our messaging, because there's always fatigue that comes into any issue. Legislators will meet, they'll do a lot of work, and then the natural human inclination is, okay, we solved that problem. We need to move on to other things, or we've done a lot on that problem. Let's step back and see how the changes that we made are actually implemented and actually make impacts on the ground before we make more big changes, right? Both of those are very natural responses. In order to keep that momentum going, one of the things that we're noticing is there is a shift in language now, and this is a good thing. Those of us who are family advocates have been talking about family strengthening, family preservation, family support. Joyce has coined the terms that everybody's using now, and that's entering into some of these mainstream conversations. So one of our goals is, let's make sure we continue to own those terms and that legislators understand what those truly mean, and the folks who are the status quo, who want to go back to the old way of doing things, don't co-opt those terms for their own purposes. But two, also understanding that, okay, maybe the parental rights, the family rights language might be getting a little bit stale. There's this new wave of family support, family strengthening that we can, because our movement has coined those terms and owns those terms, we can now shift those conversations and using that messaging to keep these issues fresh and keep that momentum moving forward.
We've got 2 minutes left. I want to at least read one more question and then ask Andrew and Joyce for 30 seconds, any final thoughts you want to leave with everyone here. So the question is, will the commissioner of the Texas Child and Family Services be willing to talk to the commissioner of ACS or OCFS in New York City or state? And were your commissioners in favor of this legislation? So Andrew, I know you can't speak for them, but if you have a quick answer, please include it. And I'll just add, because Texas will be implementing this, I'm sure Andrew and others in Texas will be reporting out about that. And when the sky doesn't fall, that can be a useful point for advocates in other states. So I'll turn to you, Andrew, if you want to answer that question, great. And then 30 seconds to final thoughts, and the same for you, Joyce.
Yeah, I'd be happy to facilitate a connection. I can't speak for Commissioner Muth. She's very, very open to reform, though. It's something I really admire about her. She knows there are changes that needs to be made, and she strikes me as a change agent. So I believe that she would be willing. I'd be happy to facilitate an introduction if that would be helpful. And the other part of that question, what was the other part of that question?
Were the commissioners in favor of the legislation?
So in Texas, our agencies are always neutral on bills. They come in as their resource witnesses. Now, that doesn't mean they don't do things to kind of influence the process, but they're actually not allowed to come out in favor of or in opposition to any piece of legislation. That's by ethics laws in Texas. Now, they can make our lives easier or harder. As I mentioned during the panel, they made our lives a lot easier because they were much more willing to talk, and they were much more willing to collaborate on how do we draft this effectively to accomplish our goals while making it easy for them to implement and understandable for them to implement. I mentioned the chair of the House Human Services Committee. We also have a chair of the Senate Health and Human Services Committee that both are really in alignment with each other in the way that they think about these issues, which is super helpful for us. That was also another leverage point. The fact that the individuals who are really responsible for your agency and are responsible for your budget want something makes it a little bit more difficult for the agency to try to oppose something that those individuals want. So having the right authors, having the right people who are advancing these reforms was a critical piece of ensuring our success in Texas.
Joyce, any final thoughts?
Donate to support change, real change.
Yeah. We're over time. Thank you all so much for joining us. Andrew and Joyce, thank you so much for your work. Assemblymember Walker, hope you're still listening. Thank you for your leadership on Family Miranda in New York, and I know that will continue. Go ahead and go back to the fight. Thank you.
Thank you.
Thank you all.